To get better insight onto the controversial government emergency law on jobs creation, I'm joined with labor law expert and lecturer from the University of Gadjah Mada, Nabila Risfa Izzati. Good afternoon, Nabila. Thanks so much for joining us.
Thank you. Good afternoon.
Right, Nabila. So as I was alluding to just now, the jobs creation law in 2020 is still subject for review. The Constitutional Court ruling it to be conditionally unconstitutional. The government had until November this year to do that, to review it, but now they have issued this emergency law, essentially bypassing that whole process. The government arguing it is an emergency measure needed to face the economic conditions this year. In your expert opinion, does it fit the criteria for emergency needs?
In general, I agree with most of the colleagues from the constitutional law background that state that no, because it does not fit for the emergency needs criteria. And it pretty much seems more like an acrobatic excuse from the government to bypass the process of fixing the job creation law, just like mandated by the Constitutional Court. And in essence, the whole process of suddenly making the emergency law is in contrast with what the Constitutional Court wish of more meaningful participation, and it's all lost again due to this sudden emergency law.
Right. So, but first, let's consider the government side for debate's sake. They argue that the emergency law was needed to help improve Indonesia's economy and help Indonesia and companies face external headwinds this year. Now, you are a labor law expert, so I want to focus on the employment laws. The government says this emergency law is needed. It will attract more investments to Indonesia. So in your opinion, does it help with that, the law?
From the perspective of employment law, I don't think that it will be. I don't think it will be much help because looking at the current state of this emergency law with all of the polemics that are surrounding the background and then until now happening, it actually even creates more legal uncertainty of the employment law in Indonesia. And investment needs legal certainty. Employment, when people want to invest in Indonesia, they want to know which law will apply to them, which employment law will apply to them. And with this whole thing that's happening in the emergency law, which actually bypassing the whole process of making sure that the job creation law made into a better law, it does not create anything good coming out of this. And if you're seeing the public response, for example, both the workers and the employer side, as at least looking at the Lapindo statement, for example, is not happy with this current employment cluster of in the emergency law. So who are we trying to please here? Like there are from the worker side, they're not happy with this law. Even from the employer side, they're also not happy with this law. So I don't think that it will be much help when we're talking about improving an investment climate in Indonesia.
Right. So I want to talk about those uncertainties. Now, the original jobs creation law was already controversial, was already protested by workers as well, who argued that it diminished their rights. But this emergency law was passed really without consulting with workers. Now, many are still expressing concern. One concern is regarding outsourcing. Article 64 stating that companies can outsource work to other companies, removing the previous bounds regarding outsourcing. Right. So, I mean, what is your take on this?
So the issue about Article 64, I think is one of the few misconceptions that going around the public due to the confusion regarding the substance of this emergency law. I would like to give a general overview first. So I would like to again point out that the majority of the substance of this emergency law number 2 of 2022 is the duplication from the job creation law article. However, interestingly, in the labor law cluster, some of the article is changed, and the Article 64 is one of these examples. So the outsourcing article, the Article 64 regarding outsourcing is previously erased in the job creation law. So this article appear in the manpower law. So we have this article in the manpower law number 13 of 2003, but then it erased in the job creation law 11 of 2020, which means that which give an idea that the types of job that can be outsourced is not regulated by the government. So so it becomes all business matter. So that's what the job creation law is actually regulated. So back then, when those articles is erased, a lot of criticism is directed towards that article, because that article give an idea that any kind of job can be outsourced, any kind of jobs. And then those Article 64 is actually reappearing in the emergency law number 2 of 2022. So, but then it has a different phrase with the previous phrase in the manpower law, which make a speculation in the public that whether this is the kind of things that make that actually good, because the government is trying to regulate the types of jobs that can be outsourced again, which previously in the job creation law is not regulated. So any kind of job can be outsourced. So, but it's not clear because the phrase is not clear, and the article only mentioned that this needs to be further regulated in the government regulation. And since the government regulation is not here yet, we don't know yet which is actually which article, what's the use of this article is actually leaning to, whether the government is trying to restrict the outsourcing or actually just trying to like even further making the outsourcing more free to be used in any types of job.
All right. I want to talk about another article in this emergency law, one that has been sort of kind of stirring up public debate as well. Article 79 stating that companies can impose 6 working days per week if they wish to do so. Now, the Ministry of Manpower said that the law does not require this, but what's your take on this and how can it potentially affect workers' rights?
Yeah, so Article 79 is actually one of another example of an article that exists from the previous job creation law 11 of 2022.
Right.
So this article is not actually a new thing. The Perpu 2022 is only copying from the previous article in the job creation law. So supposedly this would not affect the workers too much, because if we're looking at this article in the same breath with the article regarding maximum working hours, which regulated that the maximum working hours is 40 hours. It means that if you work 8 hours per day, per day, you will be subject to maximum 5 days per week with 2 rest days. So this article does not mean that it erases the 2 days rest period. It just giving the minimum 1 day period for the rest day. But like, again, because of this back and forth changing, sometimes it's confusing for the people, and it caused like a stirring debates in the public.
All right, Nabila, unfortunately, we're running out of time. Just maybe 30 seconds. Your suggestion on other ways to do this so that it can benefit both workers and investors and companies.
Well, ideally, I would like to suggest to cancel this emergency law. But looking at this current political climate, I think this law will pass into law. But so the things that we need to focus more is the government regulations that will be coming from this law, from this emergency law that will go through become the law, and then it will make another government regulation, because the current government regulation regarding employment should be changed, because some of the substance that previously regulated in the job creation law is changed in this emergency law. So the things that I think needs to be focus of the government now when they're making the government regulation is making sure that both workers and the companies are being heard when making this government regulation, because it seems that not having any participation from the public is certainly not a good idea, because the law is just not going to fit with anyone's concern.
Okay, Nabila Risfa Izzati, labor law expert and lecturer from the University of Gadjah Mada. Thank you so much for your insights today.